we're going to go into the second question. Here we're dealing with, once again, an agent has reached out to us for some advice. They have a tenant, Bruno, that is terminating their contract early, right? And the end date for the current lease agreement is only next year. But then their rental is paid up to date, and they have paid their breach over to the agents, all right? So they have been, the agents have now informed the owner that the tenant has given a notice to vacate the property at the end of November. The tenant has given the 20 business days. The owner has only sort of responded now and informing us, informing the agents that they now cancelling the mandate with the agent, and they will therefore source their own tenant moving forward. So the crux of the question here is actually surrounding whether can one claim damages for a specific month if they actually did not suffer damages and they perhaps did find a replacement tenant. So to broaden the question, that the agent is actually asking, the owner is now claiming that the tenant pays him damages for the month of December. And are they correct to say that the owner is not entitled for damages for December, as they will take occupation of the property and source their tenant? So there's not really a suffering of financial suffering there for the premature cancelling of the lease. Bruno?
So the landlord, the Act specifically provides, and this is Section 14 of the Act, a tenant, in these circumstances, a consumer, the landlord being a supplier. This is the Consumer Protection Act, naturally. Section 14 speaks about fixed term contracts and basically affords a consumer, the tenant, a way out of a contract if they don't want to be bound for the duration of the contract, right? So this was especially very nifty when it came to things like cell phone contracts and that sort of thing, where you used to have a lot of time left on your contract and you need to get out of it, right? So same thing applies to property leases. The tenant can give the notice, provided they do it with the correct time frames, which from the sounds of it they have. So that's 20 business days. So this is a right that the tenant has. Whether the landlord accepts it or not is inconsequential. The tenant is allowed to get out. So now the Act does permit or provides an allowance for the landlord to charge a reasonable cancellation penalty. Now, reasonable cancellation penalty, again, it's not properly defined. It's never going to be properly defined, because I can imagine that there's going to be case after case after case that tries to define it, and it's always going to be on a case-by-case basis. Where I do find comfort is that our law does have quite a good history when it comes to calculation of damages. Now, it's not exactly the same. So reasonable cancellation penalty versus quantifiable damages are two very different things. Quantifiable damages requires a level of proof. It is something that you'd have to go to court and actually prove that you suffered those damages, be it in the form of the rental amount or whatever the case is. Whereas a reasonable cancellation penalty works slightly different. However, there are no predefined concepts on how to actually calculate them. So again, the person works off reason. So in a case like this, can I say what's reasonable? It's difficult, but what I can say is that if the landlord has a new tenant in for a specific month, then it's certainly not reasonable, and on the contrary, it'd be unreasonable to charge a tenant for that month, even though the landlord didn't suffer any prejudice, didn't suffer any harm, didn't suffer anything whatsoever. So there I would put my neck out to say that it does sound like it is unreasonable. And what you're also going to find is that a lot of contracts stipulate what the penalty amount would be. So, for example, some contracts would say that if there's early termination with a year left on the contract, a penalty would be 2 months, as an example, right? Which people consider reasonable, because sometimes it takes about 2 months to get somebody new on the property. Another piece of legislation that might assist the tenants in these circumstances is the Conventional Penalties Act. And in that legislation, it goes, look, you're allowed to charge a penalty contractually, but if the penalty is not does not measure against the actual prejudice suffered, the person responsible for paying the penalty can challenge that penalty. So in short, even if the specific contract says that whatever, the landlord is entitled to charge for 2 months, and that second month includes December, the Conventional Penalties Act would probably also work in favor of the tenant in arguing that 2 months is not measurable against the actual prejudice suffered, given that the landlord has a tenant for December. I hope that answers the question.
Yeah, absolutely. It makes absolute sense. Thank you very much, Bruno. And I think with those 2 questions, we are at the end of our episodes today. And then we'll be coming again back next week with more questions from you guys, and we'll provide some answers. So thank you very much for this week. And that's it.
Cool. Thanks.